Yeah. Let me just make sure we're all on silent off the phone.
Stephen. Bear with me one moment, please, Chair. Okay.
Thank you. Welcome everybody to this afternoon's meeting of the hearing panel. First of all, do we have any apologies? No, none noted. Any late items? No, not from me. And I'd like to welcome everyone to this meeting. If anyone would just take the opportunity to introduce themselves and their party on this panel. I'm Councillor Steve Hassel. I'm chairing this meeting.
I am Mr. Uluido. I am Deputy Monitoring Officer and also the author of the report. And I'm my third hat. I'll be advising the panel of members.
Councillor Patrick Tatchell, member of Summersfield. Councillor Paul Hesgrave, substituting for Councillor Shiraz Khan, who would normally be here, but he's currently in hospital. Councillor Cross. Hi, I'm Tom Great Chair and waiting solicitors and I'm the investigating officer. Oh, sorry, I'm Alan Graves. I'm the victim in court.
I'm Greg Knight. I'm an independent person supporting the monitoring officer in this case.
Alan Cameron, independent person.
Wonderful.
Hi everyone, I'm Alex Huff. I'm the head of democracy. I'm here today to support both Stephen, who is clerking the meeting, and Olu with any procedural requirements relating to the complaints procedure and the code of conduct.
So that's Stephen Mason, clerk to the panel.
Yes, I understand we have a witness missing from the proceeding this afternoon. Can I ask if he was invited?
Mr. Chairman, can I request information? Has Mr. Armstrong been invited?
I'll ask. As a witness. Was Mr. Armstrong invited to this meeting as a witness?
No, he was. I wrote to Councillor Graves and said to him, as it is his witness, it's his responsibility to invite the witness.
Okay, well, unfortunately, he didn't put it in his diary and he's not in the country.
Okay. And just as a matter of procedure, I understand we have a witness on the other side of the table here. Is that balance allowed in this procedure? Not because one side is missing, we're okay with that?
I don't see any problem with that. Like I said, just in the same way I wrote to Councillor Graves and said to him it's his obligation to ensure his witnesses here. I sent exactly a duplicate message to the investigating officer, and it's for him to bring this witness and ensure he's here.
Okay, thank you. 3 then is declarations of interest. Non-noted. So item 4 is the exclusion of the press and public. I'll just read out the required statement that under Section 100A of the Local Government Act 1972, the press and public be excluded from the meeting during discussion of the following items on the grounds that they involve the likely disclosure of exempt information as defined in paragraphs 1 and 2 and part 1 of Schedule 12A of the Act, and the public interest in maintaining the exemption outweighs the public interest in disclosing the information. Can we determine whether we agree or not with the exclusion of the press and public, please?
Chair, for the record, I can say that the subject member has asked for, to my knowledge, has asked for the matter to be heard in public. Obviously, it's for him to provide you with representations and justifications why that should be the case.
Councillor Graves, over to you.
Right. I didn't realise I had to produce a justification. However, because I feel that this is about justice and injustice, I just think it would be better if it was in the public. I have nothing to hide, and I hope that the council has nothing to hide, and so we should have this in public session.
Do we have, are we, any questions, Councillor Graves, to further that comment? Sam.
Thank you. Yes, the procedure does provide to me to express my view on the point. As you'll be aware from the papers, the grounds for exclusion or for exemption, paragraphs 1 and 2 of Schedule 12A of the Local Government Act 1972 are made out in that the material in front of you contains personal information about a number of individuals and information likely to lead to identification of individuals. Obviously, the subject member is one of those, but there are also a number of other individuals identified in the papers before you, who you will no doubt potentially hear about in the course of the hearing today, and you have to consider the rights of all of those individuals in considering whether or not the public interest rests in excluding the press or public or having the hearing in public. There's reference to other standards matters, and the very nature of the allegation that's before you this afternoon obviously relates to confidential information allegedly being disclosed, and I would urge you in considering the public interest and whether or not to apply the exemption to consider the fact that the very essence of this case relates to confidential information and whether you will be able to fully explore those issues if the hearing is held in public, and also whether it will lead to the identification of individuals who are not party to the proceedings today and aren't actually present here today to put forward their own views. You also have to consider the council's obligation under the General Data Protection Regulation and the Data Protection Act, and that you owe those to all individuals whose personal data is identified in the paper, not just the subject member. So each case has to be considered on its merits, and I do recognise there is a strong public interest in transparency and accountability. But in my submission in this case, because of the factors involved in this specific case, the balance rests in applying the exemption and excluding the press and public.
Any more comments on that? Ollie, did you want to offer any?
Chair, yes. What I can say is that in the build-up to today's hearing, similar to what the investigation officer has just said, it was not lost on me that there were other third parties who have been identified in the subject member's response to the investigating officer's report. It also struck me that because of the lack of detail in that response, there was no information to suggest that those persons concerned had been sought or obtained. To that extent, and bearing in mind, for me, today, my principal responsibility here is to protect the council's position. I took the liberty of contacting those other third parties to confirm whether or not they were prepared to give their consent or had given their consent. I can tell you that at least one of the third parties has expressed in the strongest terms their objection to remain in public. And I should just say that in stressing, in making that strong objection, they have, just like the investigating officer has done now, cited not just their Local Government Act 1972 provisions, they have also cited their rights under the Data Protection Act. I should tell the panel, so it's reflected on the record, that the data subject's rights is an absolute right. And so they don't even have to give you any reasons why it is they are objecting. It's sufficient for the purposes of today's hearing for them to say they object.
Mr. Chairman, can I just add to that the subject member, as you first untitled, is under scrutiny here, not anybody else. Can I mention that your name is Steve Hassel? That's your name. Have I broken any data protection because I've mentioned your name? You're not under scrutiny here. I'm under scrutiny, and I'm here to defend why I'm under scrutiny. And talking about individuals, it is my right under the Universal Declaration of Human Rights legislation, Article 19, and the International Covenant of Civil and Political Rights, to speak about anything that has happened to me or happens to me. That is my right, and that is everybody's right. If something happens to you personally, and I am the subject member, nobody else, then I have a right to talk about what happens to me.
Can I advise the panel on that, Chair? So absolutely, Councillor Graves is correct. It's his right to enforce all his, or to assert his right to those provisions that was mentioned. However, none of those provisions give him the right to breach any other third party's privacy rights. And that's the issue which we are discussing here today. He has not sought their consent. He's an experienced member of this local authority. He receives regularly training on a wide variety of matters, including data protection law. So he will know, in many other persons, of the obligation to obtain their consent. He has not done that. That's not, that shouldn't therefore be a concern for the council beyond the fact that he has failed to discharge the onus placed on him. We've heard what the investigating officer has said. I think we have enough information there, Chair, and the panel to make a decision on this issue.
And also submit, Mr. Chairman, the people that might be mentioned, for some reason they're frightened of it, I don't know why. The people that might be mentioned will only be mentioned because it relates to the complaint against me. I am, again, the subject member, not anybody else. The only reference to anybody else is why we actually have arrived at this point. So if I do mention them, it's not about whether they're guilty or not guilty. It's the fact that they've had a part in this process. And again, as I mentioned, and Ollie was quite right about the fact I do have rights to talk about what's happened to me, and I'm here to defend what's happened to me.
Okay, thank you. I'll now conduct a vote on whether we will exclude the press and public. So all those in favour of excluding the press and public, please raise your hand. All those against? Thank you very much. Can I suggest a short adjournment while the documentation for this meeting is placed on the Democracy portal for public consumption? Thank you.
This step will take 2 or 3 minutes. So,
And we're offline.
Yeah, we are currently offline. Yeah.
Can it be noted that I dissented from the vote on making
You're not in the minutes, right?
Councillor, do you think to know about them?
Yeah, that's fine.
Okay, free to continue, Chair.
Thank you. Now that this panel has agreed that this meeting will be held in public, we will proceed with the agenda on item 5, which is the main item, complaint about a councillor. I will hand over to Olu to summarise the payment procedure to be followed in this meeting.
Thank you, Chair. And so there's three things I need to do at this stage. One is, as the Chair has invited me, I've set out the hearings procedure. And so what we will do first is I will present the report, at the end of which I will invite the investigating officer to then present his own report on the findings into it. At that stage, the subject member is entitled to ask questions of the investigating officer. And when that has concluded, then the panel, including the independent persons, may ask questions of the investigator as well. Once the investigators decide that the forum is concluded, we reverse that, and Councillor Graves will then be invited to present his response to the investigator's report. Similar to what happened on the first occasion, the investigator will have the opportunity to ask a question, and when that's done, the panel, again, including the IPs, will be entitled to ask questions of the At the end of that process, we'll move to summing up. The investigator will be invited to sum up, and once it's concluded, that Councillor Graves will also be invited to sum up. We'll then get to the stage where the panel will have to consider the weight of the evidence which they have heard from both sides, including the papers before you and any representations which you have heard. At the end of that process, when that is taking place, we do so in closed session, which will mean the public and the parties will need to go through while we have these deliberations. There's then a two-part process which we will move into. The first process, the first part, would involve the panel coming to a decision whether or not, based on everything we've heard and read, there has been a breach of the member code through the conduct alleged. If you then return to give that verdict, if you find that there has been no breach, then the matter ends there. If you find that there has been a breach, you then move into the second stage of the determination process. And that second stage will involve inviting representations from both sides as to what an appropriate sanction should be. Once those representations have been given, we will break into private session again to consider what sanction we're going to mete out. And once you've come to a decision on that, we will reconvene in public session for you to give that decision in public. At the end of the decision-making process, a decision notice will be prepared, which will set out the facts and evidence which was heard, the facts and evidence which were agreed by the panel, what the views of the independent persons were, and the reasons why it is that the decision which is ultimately made has been arrived at. And that decision notice will be published should be published within 7 days of the decision being made. So I said that there's 3 things I need to do. Second thing I need to do is just to, in light of the decision which was made about going into public session, I need to also bring to the panel's attention that when the data subject was in communication with me, they said and have asked me to ensure that if the hearing panel decides to allow their client's identity and personal data to be heard in a public session, then they would like me to repeat the points which they have set out in this email to me about why they feel that decision would be wrong, and reserve their right to either refer the matter to the ICO or civil litigation. I've given that undertaking, so I'm duty bound to tell you what they said. They want to make it clear that their client has not consented to their private information being disclosed. They want to make it clear that their client has played no part in the matter, whether as a complainant or witness, and therefore do not see the relevance of being known. They want to be clear that in the absence of those first 2 points, their client surmises that any reference to them is likely to be in a negative context and as such likely to tarnish their reputation. They want me to be clear that their client reminds the panel of its broad duty of care obligations. They want me to be clear that to whatever extent their client is likely to whatever extent their comments which are made are negative and tarnish their client's reputation, that it's not that such material is likely to cause their client distress, alarm, and harm. And that to whatever extent their client may suffer distress, alarm, and harm, that may lead to a referral to the ICO or indeed to civil proceedings, which would be costly to the council. We do not consider it within the public interest and would amount to a waste of council resources. Having done that second part, I can now turn to presenting the report.
Just to a point of clarification before we continue on, is that the panel, myself and the panel, are not aware of the subject member's name within the information you've just given. So we are not aware of that person's name, position, or otherwise, just for clarity.
And perhaps that's something which you might want to caution the subject member about the subject member here about to ensure that perhaps in protecting the council's interest, he stays away from identifying a specific person.
Is there any way that members of the panel to avoid conflict?
What's the question?
Is there any way of this person's name being known to the panel so we can avoid naming them?
No, because that in itself would create,
Indeed,
like I've said, Chair, I think the fundamental point to be aware of is that the right to privacy is an absolute right, and we don't have to give reasons. Coming to the report then, Chair. So today's session is a natural progression of a decision of the Standards Committee on 19th of December 2023 to refer the conduct of Councillor Graves to further investigation. The conduct was therefore remitted to the Independent Persons Advisory Panel, What was the conduct in question? It is that, and it's set out in paragraph 1 of their covering report, it is that on November 23rd, 2023, on a public social media platform, Councillor Graves published a video in which he read directly from a report that had previously been identified as exempt from publication under the provisions of paragraphs 1 and 2 of Schedule 12A of the Local Government Act. The second part to the complaint was that following the monitoring officer becoming aware of that unlawful publication and having asked Councillor Graves to remove the video, he declined to do so and then proceeded to compound the breach by publishing the video to other social media platforms, as well as circulating it via email to members of the public. At the time that the matter was referred to the Standards Committee, the video was known to have been watched at least 1,500 times. The report goes on to reflect that all elected members are under a duty to have regard to the monitoring officer's advice. The provision set out at paragraph 7.1 can be considered in the report itself. It's set out verbatim there. The report also goes on to say that as a constitutional provision, all elected members of the council take an oath of office to adhere to the Constitution. As a long-standing elected member of the council, Councillor Graves has of course sworn that oath on several occasions, and so is familiar with the obligations which doing so places on him. The report goes on to set out the process of engagement with the 4 members of the Independent Persons Advisory Panel, and that having consulted with them, they were unanimous in their view that the matter was serious enough to warrant an investigation, which is where I then took the reins, because for obvious reasons, the monitoring officer was the complainant in this case, and would be conflicted in progressing the matter forward. At that stage, I instructed Mr. Gocha of Wakeman Solicitors to conduct an investigation, and I will shortly hand over to him to present his report and its findings. Still on the report goes on to document Mr. Gocha's findings, further to which I again consulted with one of the IPs about what an appropriate resolution should be. The report identifies that the IP and I were also unanimous in our view, which was that while the facts surrounding the breach were straightforward and uncomplicated, the nature of the breach itself was significant insofar as it tore at the very foundations of the democratic process. The need for trust and confidence between officers and elected members in a way that enables confidential information to be shared between them. That the conduct complained about undermined that trust and confidence and the effective conduct of council affairs, insofar as it would either A, legitimize any other elected member of the council who is unhappy with the decision based on confidential pages, publishing that material just because they don't like the decision, or B, it could result in council officers no longer having the confidence to share appropriate material confidentially with elected members due to a lack of trust and faith that the members would respect the confidentiality of the subject matter. So on that basis, the IP and I regarded these as really grave considerations with the potential to completely undermine the conduct of council business going forward. And we, being of the same mind, we felt that the only realistic and proportionate resolution was to offer Councillor Graves the opportunity to provide an unequivocal apology to full council. That takes me to paragraph 4.9 of the report, which then summarizes the process of engagement between Councillor Graves and I, post the resolution proposal being put to him, as the most appropriate response to the investigation outcome. I need to be clear that the proposal was not put to him in a vacuum. It was put to him on the basis that the investigator's finding was that he had likely breached the code. And why is it important to emphasize that as I present the report? It is because when you look at his response to the proposal being put to him, it was straightforward, it was simple, no more than I accept this proposal. The report then takes us through the journey beyond making that offer to Councillor Graves, to attempting to engage with him to agree the mechanism for giving effect to an unequivocal apology by him to full council. It also takes us through his refusal to do so or to fall in line with the established mechanism for elected members to provide an apology where they are found to have likely erred. The paragraph concludes with me withdrawing that offer in January of this year when it was clear that we had reached an impasse. It's also worth flagging the significance of paragraphs 4.10 and 4.11, which demonstrates the strict adherence to the rules agreed by the Standard Committee for progressing through to a hearings panel allegations of misconduct by elected members. Paragraph 4.12 is also worthy of attention insofar as it highlights just how brief the response to the investigator's report was, and that briefness was expressly pointed out to Councillor Graves, not least because in earlier correspondence with me at the end of 2023, while we were going through that impasse process, he had been keen to stress that he had considerable evidence to offer at the hearing, and that did not appear to be borne out by his written representations in response to the investigator's report. I would say in presenting this report, it's therefore safe to assume that no additional evidence is proposed to be put forward by him today. But should that prove not to be the case, and clearly the members of the panel will be aware that we sit in a quasi-judicial capacity, and as such, you will be expected to effectively challenge any such attempt and to understand why it would be appropriate to allow evidence in late, which by his own admission was available as far back as November 2024. When you read Appendix E of the conduct process document, and I expect that as members of the Standards Committee, you're all familiar with it, you shouldn't be lost on you that the presumption in Appendix E is that you exercise your discretion sparingly. Paragraph 413 of the report deals with considerations you need to have regard to in reaching a decision at the conclusion of today's hearing. And paragraph 414 sets out a range of sanctions available to you in the event of an adverse finding against Councillor Graves at the end of today's hearing. Which leaves me with the report recommendations at paragraph 2. The determinations which you are invited to make today as appropriate, as well as giving consideration to the appropriateness of making recommendations to Council with a view to promoting high standards of conduct amongst elected members. Unless I can assist further at this stage, unless I can assist the panel further at this stage, I now propose to invite Mr. Gocho to present his report on its findings.
Thank you, Ollie. Simon, over to you.
Thank you. As the code, I was asked by the Deputy Monitoring Officer, pursuant to the Council's procedures, to investigate the referral that has been made, suggesting that Councillor Graves may have breached the code of conduct by recording and publishing a video on social media. You've heard the background from the Deputy Monitoring Officer in terms of how that came about, so I won't take you through that. I will highlight, obviously, what you need to consider today is whether or not Councillor Graves has breached the code, which was my conclusion, but obviously you're the ultimate decision makers in relation to that. And the relevant paragraph of the code is paragraph 4.1, which is set out at a number of points in your documentation. I quoted it at page 4, paragraph 7 of my report. You must not disclose information given to you in confidence by anyone or information acquired by you which you believe or reasonably to be aware of its confidential nature, except where 1, you have the consent of a person authorised to give it, 2, you are required by law to do so, 3, the disclosure is made to a third party for the purpose of obtaining professional advice provided by that third party who agrees not to disclose the information to any other person, or 4, the disclosure is reasonable in the public interest and made in good faith and in compliance with the reasonable requirements of the authority. So the question that I have to consider and that you have to consider today was whether or not in his actions Councillor Graves had reached that paragraph of the code. I've set out in some detail the background and history of this issue, paragraphs 18 onwards in my report. I don't propose to take you through it paragraph by paragraph, I'm sure you're pleased to know, but just highlighting the key points. Councillor Graves shared his video on the 23rd of November 2023. It related to the outcome of a previous complaint which arose from an incident which occurred at the annual council meeting in May 2023. In the course of the consideration of that previous complaint, the council's monitoring officer, in accordance with the procedures, resolved the matter through an informal resolution with that councillor who apologised.
Sorry, Simon, just to confirm, when you say an apology was given to whom?
The apology was given to the council and the monitoring officer.
Okay, thank you.
In light of that, the monitoring officer wrote to the complainant and informed them of the outcome. And in accordance with the council's agreed procedures, a report was then considered by the Standards Committee at its meeting on the 31st of October 2023, which was marked as an exempt item and was considered in private by the Standards Committee, and the press and public were excluded. On the 23rd of November 2023, then Councillor Graves proceeded to post the video on social media, which is what gives rise to the complaint. And I've set out in detail in my report what he said, and also you have a transcript of that video attached as an appendix to my report. The key points I'd like to highlight in relation to your consideration are that it was made very shortly after the issue was considered by the Standards Committee. At that time, Councillor Graves was the vice chair of that committee and acknowledged when I interviewed him that he had received the papers and told me that he'd been advised not to attend that meeting. In his video, he named the councillor who was the subject of that previous complaint. He went into some detail about the issue which gave rise to that complaint. He made reference to the Standards Committee, saying this committee, meaning the Standards Committee, I have to say, does not fill me with any confidence. He then went on to read out extracts from the exempt report, saying this is the exact wording on the report. He also acknowledged his full understanding that it was confidential material by saying, so whilst I am a member of the Standards Committee and I'm supposed to keep these things hush hush. So clearly he was aware of the confidential nature of the information that he was disclosing in public and on social media. He doesn't, the facts are relatively straightforward, and he doesn't dispute posting the video, he doesn't dispute that he provided the information in his capacity as a member of the Standards Committee. The question that he, as I understand it from the information that he's provided since my report was finalised, which is slightly different to what he initially said, is that his position is that either he had consent to collect published information or that he acted reasonably in doing so. And I will explain why I believe that what he says there is wrong. But I think before I go into my reasoning as to why I believe he's breached the code of conduct, it would be helpful if you considered the evidence that I considered. I obviously watched the video, and I have asked if facilities are available for the subcommittee to watch the video this afternoon. So I think it may be helpful to you, albeit you do have the transcript. So I think, and then I have a witness who is the monitoring officer who referred the complaint initially. So I'd suggest that we deal with the evidence in terms of watching the video, if that would be helpful, then calling the witness, and then I will conclude by setting out my rationale as to why I believe that the statement complies with the code.
Absolutely happy with that. Do we have that content available?
Yes, and then I will conclude by setting out my rationale as to why I believe that the statement complies with the code.
Bear with me, sorry.
Do we have that content available?
Back in May 2023. It's been some time now, and I've been thinking about an issue that arose during the mayor making ceremony back in May 2023, an injustice made by the council. You may recall that in May, I became the mayor of the city of Derby, an honourable position and one that I am extremely proud and privileged to hold. At that meeting, there was a competitive process between myself and a Labour councillor, a vote that I succeeded in. Unfortunately, during that meeting, one of the newly elected Labour councillors, Sarah Chambers, tweeted during my inauguration that I was a racist, a xenophobe, and a misogynist, none of which is true. Even though she didn't know me personally, she decided to spread unfounded gossip from what her Labour friends had told her. It became clear on sharing her thoughts about me that she soon realised her mistake and initially removed the word racist and eventually deleted the post altogether. I was informed by 3 separate opposition members from 3 different parties that this had happened, showing that a lot of people had already seen her unfortunate post. Anything that goes on social media, on the internet, is open to worldwide circulation. It was interesting that during the mayor making ceremony, the new mayor leaves the chamber to put his new robes on and then re-enters the chamber as the new mayor. It was at this point that all the Labour councillors got up and walked out. Straight after that meeting, I decided to take some advice. After all, the council employs several legal people. I went to the top of the tree and asked the most senior legal officer, Emily Feenan, what the council could do to help me and defend me from these vile accusations. Her response at the time was that she could do nothing unless a formal complaint had gone into the council through to the Standards Committee. Now, considering all options, I decided that before going down that formal path, we would approach her leader, Councillor Baggy Shankar, and ask him, through the chairman of my party, to acquiesce and tweet an apology to me from Councillor Sarah Chambers. And we would make that the end of the matter. Unfortunately, Councillor Shankar decided to ignore that email and pretend he didn't receive it. So, as advised by solicitor Emily Feenan, our next action was to put in an official complaint through the complaints procedure which goes to the Standards Committee. This committee, I have to say, does not fill me with any confidence, but it was something I was advised to do with the impression that there would be some satisfaction for the wrongdoing. Well, that process has now come to a conclusion. The process is that the officers of the council go away and consider the complaint, decide whether it should go any further, consult with one of the independent members on the committee, not any of the councillors on the committee, and only if they deem it serious enough does it get fully reported to the committee. So many decisions are made without reference to the committee or its members. Those decisions are just brought to the committee. On this occasion, Emily Feenan decided that Councillor Chambers had to apologise to the council, but not to me, for potentially bringing the council into disrepute. As a result, the complaint would be dismissed and not fully reported to the committee. This is the exact wording on the report. This complaint was made by a member of the public. The complaint relates to comments allegedly posted by the subject member on social media about another elected member. During the consideration of the complaint, the subject member issued an apology to the monitoring officer and the complaint was dismissed under paragraph 16C of the procedures. As you can see, it doesn't mention anybody's name or what the complaint was about. This is an absolute farce and typical of how serious the council takes bad behaviour from elected councillors. The report doesn't mention Councillor Chambers and is kept secret so people cannot expose the wrongdoing and her stupidity. Moreover, it is an injustice, on this occasion to me, in that I still have not received an apology from Councillor Chambers. So whilst I'm a member of the Standards Committee and I'm supposed to keep these things hush-hush, I felt this injustice needed to be exposed to a wider audience. I am sick to death of being in the Standards Committee finding very bad behaviour from councillors on Derby City Council where their misdemeanours are not recorded or punished in any way, shape or form. The Standards Committee does not have a great deal of power, but to instruct a councillor to apologise shouldn't be a difficult thing to achieve. Surely anyone that watches this video can understand that if you do anything wrong, it should be reasonable to expect to apologise for the wrongdoing that has been done. And that is all I was seeking. I didn't seek to take her to court for slander because at the end of the day, Councillor Sarah Chambers was a newly elected councillor and influenced by the more senior councillors on the Labour group. I think it is a terrible indictment of how local government and Derby City Council operates in this ridiculous situation where councillors can do no wrong in the eyes of officers that run this council.
Simon, back to you.
Thank you. As I say, the monitoring officer referred the matter to the Standards Committee is here today and as a witness that I involved part of the process, so I'd like to call her to give us evidence.
Yeah, just before.
Coffee break, 2 minutes.
Should we adjourn?
We'll have to adjourn because you can't park here. You won't be able to park here. So if you don't do that, we'll need to adjourn before we want to have a coffee break.
You've already introduced yourself, is it?
Yeah, my name is Emily Feenan. I am Director of Corporate Governance, Policy and Procurement at Derby City Council.
And you referred this matter to the Standards Committee under the Standards Procedures.
Yes, I did.
And it was the Standards Committee that determined it should be investigated. And we've heard from the Deputy Monitoring Officer that prior to doing that, some attempts were made by you to informally ask Councillor Graves to go. Is that correct?
Yes, that's correct. I emailed Councillor Graves on the afternoon of Friday, November 24th, and I informed him that I'd been made aware that yesterday, the previous day, he published a video on Facebook in which he clearly stated that he was quoting directly from the confidential report of the Standards Committee, and advised him that it was a potentially serious breach of the Code of Conduct. The the implication of which we discussed with due cause to the need on else that he remove the video immediately. Councillor Graves did not remove the video. I subsequently emailed him again on the 27th of November and again asked that he remove the video, remove the post from the other forms of social media, which he had subsequently also posted on after my initial advice to him. But again, he did not do that.
Was it at that point then you decided that you would go back to the standards?
Yes, I think it's important to set some context. I've been the monitoring officer at Derby City Council since 2018, and in that time I've not had cause to use the provisions under paragraph 26 of the standards procedure. That procedure states that under certain circumstances it may be necessary for the monitoring officer to refer matters to the standards committee, which has not at that point been raised as formal complaints. And that may arise, for example, where the monitoring officer has been aware of conduct which may constitute a breach. I think it's important to set this context, so I do not use the provisions of paragraph 26 lightly. However, the disclosure of confidential information is, in my view, potentially a very serious breach of code. And following Councillor Graves' publication, I received a number of concerned queries from fellow officers at the council regarding that post. I therefore consulted with the Chief Executive and the Head of Democracy at that time, and we discussed what the next step should be. We agreed that given the potentially serious nature of this breach and its implications for the way in which the council conducts its business going forward, that it would on this occasion be appropriate for me to refer the matter into the Standards Committee for them to consider whether it was warranted further investigation.
Thank you. Could you just explain a little bit about why the outcomes that are reported to the Standards Committee are reported in the part of the meeting?
Yes, it's been a long-standing position of this council and that the anonymity of subject members should be maintained until such point as a finding of a breach of code of conduct is found by hearing panel of the Standards Committee. That has been the subject of discussion at Standards Committee on numerous occasions, but the position of Standards Committee has been to maintain that board position throughout. That is a matter for members. Officers provide advice to committee, but it is a position for members, it is a position of members, and it's important to note that the Standards Committee is not what we call a wisdom committee. On that committee are representatives of all political groups, and they have maintained that position for a very considerable period of time. And it's also important to draw attention to the fact that the Derby City Council's practice in maintaining anonymity is entirely consistent with good practice, and it's a position maintained by the vast majority of local authorities across the country, and is also in line with guidance from the ICF.
Sorry for people, I'm sure everybody is aware of the information.
Apologies, yeah.
So that's in relation to ensuring that the council meets the estate specifications.
Yes.
So in terms of the, I'm not going to ask much about the specific complaint that Councillor Grace talked about for obvious reasons, but he throughout the recording that we just seen refers to our complaint and we. Was he the complainant in that case?
No, he was not. The complaint was raised by another individual. That individual was expressed themselves in the public. They did not identify themselves as having a party political affiliation, or that their complaint was made on behalf of Councillor Alan Graves or a political party.
And they were notified of the outcome of their complaint in August, I think.
Yes, that's correct.
And did they raise any concerns with you about interview with me, you referred to concerns that you had about previous leaks of confidential information from the council. Just to be clear, were you suggesting in telling me that you believe that Councillor Graves had been responsible for those leaks?
Absolutely not. In my interview, I was attempting to convey the unique nature of this disclosure by Councillor Graves. So there has, in part, been breaches of confidentiality. However, those have been anonymous tip-offs to local media, which have never been attributed to an individual political party or to an individual councillor. So I've not had the ability to investigate or for those to be raised as a standard complaint because there has not been a subject member to raise that against. As I said, I've been the monitoring officer since 2018, and in that time I have not experienced a breach of this nature. And I mean that in the context that this was a deliberate and planned decision to breach confidentiality, and that's clear. We've just watched a video in which Councillor Graves explains how he came into possession of that confidential information and how he understood its nature as confidential. So it was a deliberate and planned decision to make a breach. And there are exemptions to the requirement to maintain confidentiality under paragraph 4.1 of the Code of Conduct. But it's clear that Councillor Graves has not sought to comply with any of those exemptions. No authorisation has been sought, no consent has been sought in advance. And so, from my perspective as a monitoring officer, this was, as I said, a unique and serious breach that goes to the very nature of how as officers we share confidential information, which is essential to the working of this council with trust and confidence that its confidential nature will be maintained.
As the monitoring officer with statutory responsibilities, what do you think the implications would be if councillors were able to, without any process of authorisation from the council, disclose publicly material that they've been provided in confidence? What impact would that have on the operation of the council?
The reasons for my referral to the Standards Committee were set out in paragraph 4.7 of the report to Standards Committee on 19th December 2023. And I think that paragraph of that report very clearly explains why confidentiality is so important. And so I will read from that paragraph because I don't think I can express it in a better way in many respects. The deliberate disclosure of confidential information and the failure to act upon advice provided by the monitoring officer represents potentially very serious breach of the Council's Code of Conduct. The same statutory provisions are used to ensure the security of sensitive information provided to councillors at other committee meetings, for example in cases of commercial sensitivity or where information is subject to legal professional privilege or where personal information is included. Failure to uphold this element of the Council's Code of Conduct set a precedent that confidential information could be openly disclosed, exposing the Council to significant financial and reputational risk, for example in failing to secure best value in commercial negotiations or in fines from the Information Commissioner resulting from data breaches. Officers' ability to effectively share confidential information with councillors is entirely dependent on them being able to trust councillors to maintain that confidentiality. I would go on to say that in many respects the specific nature of the information disclosed by Councillor Graves was in many respects irrelevant. What is key is that information was confidential. It was clearly marked as confidential in the report header. The Standards Committee had resolved to exclude the press and public when the report was considered. And Councillor Graves himself stated he understood that it was confidential. Clearly, it is not for councillors to be able to pick and choose when confidentiality provisions apply according to what suits their own personal agenda. The Standards Committee discussed the need to keep information confidential Graves Standards Committee members had resolved that the summary of this complaint should be confidential. Yet Councillor Graves chose to disrespect the resolution of his fellow Standards Committee members in disclosing this information. It's not just his own relationship with officers that Councillor Graves is potentially undermined here, but it's the relationship between officers and all 51 councillors. It's hard to imagine that if the Standards Committee does not uphold this as a breach of code of conduct, that it will not have a chilling effect on the ability of officers to breach councillors on the most confidential information.
Did Councillor Graves seek any advice from you, or as far as you are aware, any of the legal officers of the council before the video?
I'm not aware that he did, he definitely did not.
And as you know, he didn't seek any consent from you or from the Standards Committee before disclosing the information?
No.
This is a hypothetical question, so you may or may not be able to answer it, but if, in your opinion, if he had sought your advice or your consent prior to doing what he did, what would you have thought?
I would have advised him in the absolute strongest terms that he should not make disclosure of publicly generous terms.
Thank you. That's all the questions that I had. I think the process is that the subject member can ask questions of the witnesses, although it's slightly late in the process, it would seem to be the sensible time that happens to be now to get to your views of the subject.
So I'll go over to you, Councillor Graves, to question Simon and Emily as his witness. I have to remind you that it is questions and not statements that you're doing. And can I just reiterate Olu's advice at the beginning of this meeting around the disclosure of names, etc., just so you're well aware.
Jack, just to be clear, I would suggest that the appropriate time for questions for me will be at the end when I've gone through my reasoning of why I think there's been a breach of the code, and that the questions now is for the monitoring officer on what she said. I'll then make my representations on why I think there's been a breach of the code, and at that point, Councillor Graves, I would suggest it would be, because then he can ask me all the questions wrapped up in one, rather than asking me questions now. I think the procedure does have it as the next step afterwards, but I think it makes more sense to do it that way.
Not according to my procedure that I've got written in front of me.
I do find it a bit odd
yes,
that people representing one side of the argument here is telling you how to run your meeting.
Yeah, I would much prefer Councillor Graves to offer his questions to both parties at this point in the meeting, and then we can proceed.
Would you want me to finish my submission then, Ron?
Yes, absolutely. Yeah.
Thank you. So you've heard the evidence, you've seen the video. It's then why I reached my conclusions that, in my view, Councillor Graves had breached the code in recording and publishing the video that he did, and that's set out in paragraph 66 to 80 of my report. I draw your attention to initially in his response and in what he said to me, he suggested that he didn't believe he disclosed confidential information. On my understanding of what he said to monitoring officers since the report went out, his position is slightly different. And in my view, it's quite clear that he knew that the information that he disclosed was confidential. Whilst there were no names mentioned in the specific extract that he read out from the Standards Committee, there was a lengthy preamble where he explained to those people watching exactly what the complaint was about, who the complaint was against, what the outcome of it was, and what the subject matter was. So the fact that the extract was anonymous does not mean it wasn't confidential. It clearly was confidential, because you have to look at everything that he said as a whole, and he clearly disclosed confidential information, which wasn't even considered as confidential information by the Standards Committee because of the views of the Standards Committee on the process and how confidential it must be. And he specifically says he knew he was supposed to keep these things hush-hush. He knew it was confidential, and the details that he spoke about in the video were clearly confidential. also said that the information was about him. He talked about confidential information that relates to him, and he said that again today. Well, yes, but not in isolation, as you've heard from the Deputy Monitoring Officer. That has to be considered in the light of the rights and freedoms of others, and the confidential information was also about the subject member that he was referring to. It was also about the complainant, because remember, it wasn't his complaint. He was not a party to the complaint. He hadn't made it. It wasn't expressed to be made on his behalf. So he was not a party to that complaint at all. He was talking about somebody else's complaint about somebody else. And the council's procedures say that the outcome of that is confidential, because there was no finding and no hearing. And in his evidence to me, Councillor Graves made it clear that he knew that details of standards complaints are only public if there has been a finding and a hearing that a member of the code. So he was absolutely fully aware that this was disclosure of confidential information, and he was not a party to the complaint that it was about. So the next question is, well, can that be justified under the test in the code? And in order for that to be the case, he would have had to have either obtained the consent of a person authorised to give it. It was the Standards Committee information. It was the Standards Committee that had made it exempt, and he's certainly not obtained any consent from the Standards Committee to the disclosure of that information. He's not obtained any consent from the monitoring officer under the procedures either. He's not he's not provided any evidence of who he says has authorised it. So that ground can't be relied on. The next potential ground available to him is reasonable in the public interest and made in good faith and in compliance with reasonable requirements of the authority. And in my submission, that is not made out. He did not seek any advice or information. He did not try and go through any formal processes to express any dissatisfaction about the way that the matter had been treated. Neither did the complainant who actually made the complaint. He must be taken as a member of the Standards Committee to be fully aware of what the Standards Committee's processes are and the reasons why these matters are considered exempt and not made public. He did not make any attempts, or there's no evidence that he made any attempts to challenge what had been done, to say that he wanted the matter to be reconsidered by the Standards Committee, that he wanted issues to be made public. He simply went out and recorded a video and posted it on social media, clearly showing that he knew he shouldn't be doing it, because he had made reference in it to the fact that the matter should be hush-hush. You will be aware, I'm sure, as a Standards Committee, that the Local Government Association has issued guidance on the Code of Conduct and its application, and that makes reference to the disclosure of confidential information and when disclosure in the public interest will be justified. And it specifically says the disclosure must be made in good faith, and that will never be met if you act with an ulterior motive, for example, to achieve a party political advantage or to settle a score with an opponent. The fourth requirement, and this is an and, not an or, you comply with the reasonable requirements of your local authority, means that before making the disclosure, you must comply with your local authority's policies or protocols on matters such as whistleblowing and confidential information. You must first raise your concerns through the appropriate channels set out in such policies or protocols. No evidence that Councillor Graves made any attempt to do that in respect of this issue. So that was why I reached the conclusion that he had breached the code by disclosing that confidential information, and that he knew full well that he was doing so. Also, you'll be aware from my report that I shared a draft of my report with him prior to finalising it, which is standard procedure. He did not make any comments on the report. He didn't say that he disagreed with anything. He didn't say that anything was wrong. He didn't object to anything. He then subsequently engaged in lengthy correspondence, which you've heard about, with the Deputy Monitoring Officer, indicating that he would be willing to make an apology, which suggests that he was aware that there was something that warranted an apology being made for. So that's the reason why I concluded, and in my view, having dealt with many of these types of cases, it's a clear-cut case. He was in breach of paragraph 4.1 of the code.
And is that your final
That's it.
at that point? Right. So, Councillor Graves, again, I'll go to you to offer questions to both Simon and Emily, and again, caveat from what I've
So
said.
I want clarity that it's the questions, but not my statements.
It's all of it.
No, all of it.
It's just questions at this point. Sorry. Yeah.
Okay, my questions are to Simon. He's been paid a lot of money to do this. When you don't have a lot of money. My questions are to Emily. So when I asked you for help and advice in 2023, you told me that a formal complaint had to be submitted to the council to be able to deal with it. Did you not feel the statement made by Councillor X, who I'm not allowed to say her name, breached the standards expected of councillors?
Grace, you'll also recall that after the AGM, you and I met with the Simpson, to the Chief Executive, to discuss general practice within council, because you understood quite legitimately you got concerns regarding level of behaviour in the chamber, and we also looked to how we could address that and what options were available to us. You were, yes, you were advised that something needs to be made.
Okay, but I particularly want to know, did you feel that the statements you made breached the standards expected of council? Thank you.
I was uncomfortable with her statement, and that was raised, and that councillor withdrew her statement and offered to recognise that it had the potential to bring council into disrepute and make an apology.
So you did feel that it breached the standards expected. Why did you not consider bringing the complaint yourself, as you did with me?
I think the two cases are completely distinguishable, and there are clear distinguishing factors. Firstly, in your case, you refused to heed my advice as a monetary officer, which is a requirement under paragraph 7.1 of the Code of Conduct. And actually, when I advised you, you further compounded the breach by further publishing. Secondly, in relation to your breach, significant concerns raised by officers, and your breach had wider implications for all councillors and for council business. In addition, you understood what you were doing. It was a deliberate and planned decision to breach by an experienced councillor. You have been a councillor on and off since 1995 and a long-standing member of the Standards Committee. And your breach had wide implications for the council. In comparison, the councillor who was a subject member of the previous complaint we referred to behaved very differently in light of that complaint. She amended, then deleted the post, recognised the original version of the post had potential to impact and distribute, for which she apologised, and it would be mindful about what she posted on social media in the future. The two cases were clearly distinguishable from the behaviour of subject members.
At what point did you realise that you were not the appropriate officer to investigate my case?
It was entirely appropriate for me to indicate the third matter in the Standards Committee at that point of September.
So with my video focusing on criticism of your advice and support, did you not consider that making the complaint yourself might be an abuse of your powers with the rules of the Standards Committee?
Councillor Groves, I did not consider your video to be directed at me at all. You referenced my name on several occasions and you state what I advised. I didn't consider that you were making a direct attack at me. It's interesting that you considered that you were. And therefore, I considered your complaint, your behaviour in the nature of was there a breach of code of conduct? And in my view, there was a breach of paragraph 4, and that's what I focused on.
So you don't accept the fact that there was some criticism advice to nurse?
In the video, you said you asked my advice, I gave you my advice.
So
You
similar,
raised quite pejorative comments about the behaviour of officers in general in the council. But that happens on many occasions in the role as monetary officer, and I don't choose to react to all of them.
so similarly, do you consider that a person that is a focus of criticism should be allowed to present their own complaint and influence the decision of this committee? And would this be allowed at any other time?
Sorry, I don't understand the question.
So obviously you were part of that video, and you were part of the complaint that I had in the fact that I openly criticised you for not giving me or not directing me in the right way, and so therefore you being complainant, you are subject in that subject video. You are subject to that video. So do you think it's right that the complainant should be allowed in this committee to present that complaint?
Firstly, I'm not presenting a complaint. But secondly,
So,
I
but
don't
hold on,
believe
but
that
you
you,
did
I don't believe that you, the type of guy you stated what you asked of me. I gave you clear advice that it's a standard of compute for you to raise. That's correct advice. I haven't done anything incorrect. There's nothing to complain about in that nature.
So you don't regret making this complaint?
No, I regret that the council has been put in a position where this complaint has had to come forward. It is extremely regretful that confidential information would be disclosed by a experienced councillor. It is unfortunate that we are in this situation. We've not had to have a hearing meeting of the Standards Committee since I've been monitoring officer. However, I truly believe that this is a thin end of the wedge matter, and we need to consider the implications of a breach by a councillor of the confidentiality provision.
Thank you, Councillor Rhodes. I'll open questions up to the panel if they have any. Anyone wish to offer some questions to Simon or Emily? Pardon?
I have a few.
Okay, Councillor Prosser.
So, to Simon's here, so would you agree that by letting his party chair, who made the original complaint, first to the Labour Party and then through the council, Alan made a concerted effort to handle the complaint with care, diligence and integrity? So this was the previous complaint. So you've made every effort to resolve the situation in a calm and measured way. Would you agree with that?
I think if it was me, I would have initially contacted the subject member myself and asked them to remove the post and to apologise. If it was me, I would have made the complaint myself because it's about me. Clearly, a process was gone through. I don't understand, and I did ask Councillor Graves specifically why he didn't make the complaint, given that it was about him. And he told me he had his reasons, but he wouldn't tell me what they were. So I don't understand why he either didn't make the complaint himself, or if the complaint was going to be made by the party on his behalf, it wasn't expressed to be made on his behalf.
So how would you express the complaint on someone's behalf? Is there a way on the form saying I'm doing this on behalf of?
Yeah, you just
So have in the complaint made, and I know that people are not party to this, in the complaint made, the complaint is clear that the process was followed as chair of the party on Alan's behalf when it was sent through to the Labour Party and onto the committee. So it's quite clear in the original complaint that he was acting on Alan's behalf.
no.
And I just wonder why that's not been taken into consideration. Emily denied that in her statement, but actually in the original complaint, it's quite clear from the writing. Although it doesn't say I'm acting on behalf of Alan Graves, it's quite clear that he is acting as the chair of the party. Why I'm bringing this up is that obviously I'm the party, so I
very simple and straightforward to say this complaint is being made on behalf of Councillor Gray. It did not state that.
Okay. Could I read out something from the complaint?
Yes, as long as it's within the bounds that we've already discussed.
Sure about propriety of a member introducing evidence.
Okay, well, sorry, I won't do it, but I will just say that it's there. In that the complaint was made on behalf, and it is quite clear in the application in my eyes. And I find that quite strange. But as there's no official way of declaring that on a complaint form, I don't know what else you could have done.
Yeah.
Councillor Prosser, just if you don't mind, I've just had a quick chat with the chair. If you want those papers introduced, I can make arrangements for them to produce now, if you do.
I'm not. My concern is that obviously we're concerned about naming people, and we're concerned about how this goes and information coming out. So it might be nice to share a specific part rather than the whole document.
Yeah, I think you're talking here about the complaint from 2023.
The original complaint before this one.
The reason why I'm asking that, and I need clarity on it, is because quite clearly it's not been produced in evidence. However, what you're suggesting in the conversation with Mr. Goja is seeming to suggest that there is a difference of opinion about what that 2023 contains. And I think in the interest of clarity, if that's what you're saying, so as to it's worthwhile having that 2023 complaint paper produced.
I agree. I would say that I am saying there is a difference of opinion, and I would like perhaps an extract of this, if that's possible.
I have it available. There is a lot of personal data contained in the document, however, so I need to know which bit you want to see.
Under attempts of conciliation, right towards the end of the application, there are 2 paragraphs. In fact, you might have to remove somebody's name.
I can read that out if that would be helpful.
Yeah,
yes,
the complaint ends with attempts at conciliation. I have attempted to reach out to the Labour leader via private letter. See document Reform Derby Party libel claim versus subject member, June 2023, in order to try and resolve this matter in an amicable and private way, but at the time of writing have seen or had no formal or informal reply to the letter. I therefore seek that the Council make investigations and take any and all necessary actions to resolve this matter in the way requested, and for the subject member to give an undertaking not to make such defamatory comments and posts again to any members or other parties. I reserve the right to take any other more formal legal action should this matter not be resolved by the Council. Bear with me, we go on to the next page. That is.
I wonder, Councillor Prosser, if having then heard that read out, you just want to repeat the question you were asking us to Mr. Goji so we can respond to you.
So, knowing that the application is done with an email address from the Reform Party, and that those 2 paragraphs are there where clear attempts have been made on behalf of the Reform Party, is it reasonable to conclude that the person making the complaint is not necessarily acting on his own, but may have some affiliation with the Reform Party?
It's not uncommon for people to use all sorts of email addresses to make complaints. It doesn't necessarily mean they're making them on behalf of the organisation that they have had the email address from. It would have been very straightforward to say, I am making this complaint on behalf of Councillor Graves. It doesn't do that. It says, I have attempted to. I therefore seek the Council. I reserve the right, and then it's signed by the complainant, not by Councillor Graves. I don't understand why that very straightforward paragraph, if that was the intention, wasn't added to say, I am making this complaint on behalf of Councillor Graves or the Reform Party or both.
No. I mean, his name is not unknown as his position in the party. So,
but I think to make an assumption that someone's supporting a complaint when they're not named, they haven't signed it, there's no indication they even know that it's being made, would it itself be problematic for the monitoring officer?
do you think that this committee should treat, or the standards committee should hold complaints differently according to who
express any dissatisfaction with the outcome.
You express it, and there is an opportunity to complain to the ombudsman if you feel your process is not progressing.
No, it clearly says that it's final. It clearly says it's final. There are no alternatives according to the complaint. So that's quite interesting. So I'm going to have to ask Emily on that one then. So Emily, in the meeting where Alan was excluded, I stepped in on his behalf, and me and you had quite a heated discussion. As party chairman and leader of the group, and substitute at that meeting, would you not say that I expressed dissatisfaction with the outcome of that complaint? Okay. And what options were perhaps available to me on that occasion?
What options available on that occasion? Your dissatisfaction with the outcome of that complaint was entirely linked to the discussion about the referral of the matter concerning Councillor Graves into the standards matter, and your view that the two should be linked.
No.
That was the point you made about. Yeah.
So the complaint, this first complaint that was about Alan, not about Alan. That complaint came to standards committee. The bit that Alan read out on the three papers. I was at the meeting where those three papers were, and I expressed a very strong opinion about the outcome of that complaint. Right. So, what could be done from that point about that complaint? What options were available to me or to Alan? Because as his leader, I was expressing that we weren't happy with the results. Personally, that's the thing. What options were open to us? What advice could you give that we could move something forward or actually do something better about it?
So, first, you didn't seek my advice on that point.
Well, I did in that meeting.
No, you didn't. You didn't ask my advice at all. You told me that I got it wrong. Secondly, there were options available to Councillor Graves and yourself all the way through this process from the date of the AGM. You could have made the complaint yourself as councillors, and that would have led to not a different process, the same procedure being followed, but may have led to different outcomes, i.e. where the apology was directed, for example. You chose, for whatever reason, which has not been explained, not to pursue the complaints yourself. Secondly, you hadn't made that original complaint, so you did not have the option of referring that to the Ombudsman, but the original complainant did. And that is available to him, and he could have done that. But he was not present. He has not raised any further queries about next steps, and so that was not for me to provide that advice again. I think it's really important, when a standards complaint is submitted to the council, it is taken on face value. That is all that can be done at that point. The form is submitted, and it is not for me to infer, or for the standards process, to infer motive or aspiration of outcome on a complaints form. It is to take the information contained within it and to follow our very clear processes for dealing with it, which is what has been done.
We do infer motive, because if you feel it's politically motivated, then you will vote out. Like you say. So there is some judgment there.
There is a route for that to happen, and then don't vote out. It is referred into the political parties for resolution, and we ask for follow-up. And that is generally where it is a councillor against councillor complaint.
And obviously, you try and sum up whether it's a personal attack, whether it's a personal, I really don't like Councillor Hezzy did, like other personal grief. You try and work out if it's a personal problem or whether it's something that you need to deal with.
No, I don't take that approach. I don't infer that. As I say, there are occasions when we have councillor against councillor standards issues, where we may have a sort of tit-tat complaints process where a complaint is made against one councillor and a complaint comes in on the other side. Those are the sort of complaints which the politically motivated provisions of the standards procedure apply to.
Finish, Councillor Prosser?
I didn't nearly. I'm just checking.
I have a question if it helps while you're
Okay.
searching for yours. Yeah, I've got a question for Emily, if I must, please. In your opinion, why do you feel Councillor Graves took the action he did in producing the video?
I don't know why he would do that, given that he is highly experienced, has had numerous sets of training on code of conduct and understands decisions of it. I have no understanding at all why he would do something.
Okay, I suppose my question is, why do you think he was motivated to make it then?
I don't know.
Do you think he felt that the process undertaken in the complaint wasn't to his satisfaction, or the outcome was not to his satisfaction?
He suggests that in the video.
So I'm just trying to get some context as to why he would put himself in that position. He's clearly undertook this action because he felt there was inaction in very basic terms. Okay.
I think it's important to note that there were other avenues available to Councillor Graves for addressing what he perceived as failures and or lacking in standards process. And actually, as you are aware as Chair of the Standards Committee, the Standards Committee has subsequently, on the basis of some concerns raised before Council, and established a working group to look at various aspects of the standards process, including how complaints are resolved informally and on a local basis, and has taken that forward. And that is the proper way to deal with things, and that has happened.
And it's clear from Councillor Graves' video, what I can see, his resolution, the resolution he wanted was an apology. I think that was quite clear from the video. Clearly, the subject member apologised to the council for that breach, but obviously an apology to Councillor Graves was not forthcoming. Was you aware of that situation? Was you aware that that was his desired or a desired outcome from that process?
No, at no point did Councillor Graves requested an apology from the subject matter councillor via myself or the democracy team. At no point did he express that's what he thought. He didn't raise a complaint. He didn't express that's what he wanted. He expressed that he was disappointed in that had happened, what could be done, and I advised him to submit a standard complaint. I think it is fair to say that if Councillor Graves had submitted that complaint himself as a councillor and the mayor, then it would have been a potential outcome that the apology would be made directly to him. However, as the complaint was submitted by a member of the public, then it was therefore, it would not be appropriate to ask a councillor to make an apology to another councillor simply because the member of the public can't support it.
Mr. Chairman, I want to interrupt.
Not at this point.
It's just on that particular, what your question and the answer.
Yeah. And finally, had Councillor Graves requested to you directly to say, well, please can you get the subject member to apologise, is it within your powers and discretion to facilitate that?
Sorry.
So if Councillor Graves had approached you to say, I would really like an apology from the subject member, is it within your powers and discretion to have facilitated that?
Yes, I think in the context that we regularly hold discussions with group whips, I try on many occasions, matters are referred to the monitoring officer, standards about conduct referred to the monitoring officer on a regular basis. And there are various avenues for the resolution of those. Often we're able to resolve those very quickly, informally, through a conversation with the subject member or the group whip. without having to progress into the standards process. And we do progress those. So there were various options available to you, but I have to make it absolutely clear to the hearings committee, at no point did any reform councillor from Derby City Council state that what they were seeking was an apology directly to the council.
Just on that, while I appreciate that that is the case, however, we all know that this matter has gone on far too long, and I think everyone would agree we shouldn't really be here at this stage after such a lengthy period of time. However, having seen the video and witnessed what Councillor Graves had said in his offering in that video, do you think it would have been appropriate for you to intervene to resolve this matter and seek, because it's clear from that video, he wants it, from me watching it, he wants an apology from that person. Do you think it would have been the right course of action and appropriate for you to, while not being told officially, you can see from his video, he wants a reply, do you think you could have intervened by going to that subject matter and look, please draw this to a close? Is there any way you could offer an apology, mitigate that apology is what I'm saying, in a way to try and draw this matter to a close well before today?
I'll make 2 points on that. Firstly, the complaint, the previous complaint had already been closed, it had been reported in standards committee and it was closed. But secondly, I think it would be highly inappropriate to effectively reward a breach of the code of conduct by taking extraordinary steps in relation to an already closed complaint.
But you will accept that the result of Councillor Graves' opinion of the outcome of that complaint was, to his opinion, unsatisfactory, and that's, I mean, we can ask him, that is why he took the action he did. So from my position, quite clearly, and it's not a legal position, it would seem the common sense thing to do to try and intervene to resolve the matter with the information you had at hand. While it wasn't given to you sort of officially, you was aware that an apology was in the ether. That was the reason. That seemed to be his motives. And I think, I wouldn't speak for everyone in this room, but I would assume that many would assume that from that video. You think you could have intervened before to try and resolve?
With respect to, I think that fundamentally misses the point of the complaint against subject member here today. The point of the complaint against subject member here today is that there was a breach of the code, a potential breach of the code of conduct which extremely serious and breach of confidential information. That is what is being considered today. It is that breach.
It
Not
is.
my subsequent conduct in relation to a complaint which is already closed. It is whether Councillor Graves breached the code of conduct, not myself.
Correct. However, I think it is very important to understand the context of what has happened here and why this sort of catalogue of events has evolved and gone on and all them sorts of things. What I'm trying to get at is that could have been an earlier intervention, regardless of what's happened, and that I know we're here for that today, absolutely. However, it would seem to me that you held enough information to able to make a considered decision and a common sense one to try and resolve a matter well before this point.
I think the key point to consider there is, would that have dealt with the breach of the code of conduct by Councillor Graves? Would it have dealt with his breach of confidentiality, or would it have dealt with fundamental undermining of the relationship of trust and confidence between councillors and officers and sharing confidential information? And I think that is what is key. So yes, I can understand the desire of the committee to consider the motive behind Councillor Graves' breach. However, as I said in my response to Simon when he asked me the question, it really is almost irrelevant in the context of this particular case, the information that was disclosed by Councillor Graves. What is the most relevant point is that this was confidential information. Councillor Graves knew it was confidential information, and he deliberately and in a pre-planned way chose to reveal that confidential information on social media in many different platforms.
But just to, sorry to labour the point, but I would assume that your attempts to resolve this matter when it happened was to get, and I think you did request that Councillor Graves remove that video. That would have resolved the matter.
No.
Is that no?
No, I make it clear in my email to Councillor Graves in both of my emails to Councillor Graves that the implications of what he had done in broadcasting that video were extremely serious and would be considered afterwards, but to mitigate the damage that was being done by his publication, he should remove it immediately. To reduce the number of times it could be used. As Councillor Graves said, when something goes on the internet, World Wide Web, it can be seen all over the world.
So just for clarity and to be clear, had Councillor Graves removed that video, that wouldn't have resulted in the further complaint that we're here today to discuss.
Potentially not. However, it would have been stronger mitigation for Councillor Graves, and that he would have immediately, had he been not to breach paragraph 7.1 of the Code of Conduct, which is an obligation on all councillors to take into account the advice of the monitoring officer, which Councillor Graves chose on 2 occasions not to do. I have to say, Chair, that is an extremely unusual position to be adopted by council.
Councillor Prosser. Councillor Atwater.
Chair, thank you. Can I just ask what this investigation has cost Coventry Council so far?
Do we have any?
No, we don't have those figures available, but I have to say, Chair, that I don't see how that advances the question of whether or not Councillor Graves has breached the Code of Conduct.
Councillor Prosser.
The apology that you received and that you subsequently dismissed the complaint, did it admit any wrongdoing on behalf of the member, or did it simply apologise for potentially bringing the council into this?
I have a copy of that.
I think that's quite important because that's what the complaint was told us. So he wasn't aware of any acknowledgement of guilt as such, but purely that they might have thought the council was accused. And that does make a big difference to the complaint, whether it's guilty or not. In my opinion. Also in paragraph 43 of your interview here, you said you were aware of background information, things that just happened into the run-up to the annual council meeting, and that your decision was taken in that light. And I'm not aware of any bad behaviour, certainly on the part of my party, in the run-up and during the election. So I don't know how that could have influenced your decision. I'd like maybe you could explain it.
And so for the benefit of the committee, I am the council's returning officer, and so I am therefore responsible for the fair and safe conduct of the council's elections. I received complaints from candidates and agents and members of the public in the run-up to the elections. I was a third party to a number, significant number of reports around behaviours in that ward between different political groups in the run-up to the local elections. I'm aware that those were, I'm not going to express the ward because of the restrictions on naming, and those were reported into the police on several occasions and were the subject of police consideration. I was aware, therefore, of that context, not that I believe that excused the...
Well, was that relevant to Councillor Graves' policy? Those complaints and issues?
Yes.
Really? I'm sorry, I am completely unaware of anything you are talking about. Okay. So that is absolutely share something with me afterwards, that would be nice, because, you know, we like to resolve any issues. It's quite a shock that you would say that we had such issues. Yeah, good. I think that's an absolute right, and I wish actually if you have any problems with our party or anything against it, it would be shared very quickly, because we like to get on top of things. And I agree with you, but you're aware that anything. But the only thing I was aware of in that election was that.
Councillor Prosser, can I just remind you to stick to questions, please?
Okay. Yeah, no, all right. But I'm aware of things that happen, but not regarding our party, and I am aware of some very serious accusations that are similar to this complaint and other complaints were made at the same time. So at the same time as this, were other similar complaints about social media and accusations of racism handled by the Standards Committee. Okay, I can tell you that we were.
I can't recall. I don't have that information in front of me at the current time. We deal with a number of complaints.
Well, it was quite memorable to me and other members of this committee, I'm sure, that accusations of racism were made against many councillors during that election, and nobody.
Councillor Prosser, can we stick to questions about this hearing?
Would it?
Yeah.
I'm trying to phrase it in that, would it be normal for many accusations of the same thing to come about? And no real, quite serious accusations. All right, I'll move on. It's just, it is just quite, it was quite a time, as you say, but not, I don't remember it the same way as you do. So, okay, all right. I'm really good. If someone comes under, so Simon, if someone comes under a personal attack, and that personal attack is not dealt with, would it be reasonable for the council to insist and stay silent? Okay. All right. It's just, you said it was, you know, reasonable, whatever you've mentioned that, so I wanted to repeat that. In paragraph 75, you state that this right with the protocol should be raised through this proper channels. So, are you aware that actually it's been a bone of contention to how the Standards Committee works, and that Alan and many others have repeatedly raised the protocol publicly about the Standards Committee and issues with the Standards Committee?
I understood the monitoring officer, the Standards Committee has considered issues around how it receives reports back of complaints on a number of occasions, and obviously has adopted the process that it currently has, which is a matter for the Standards Committee, as the monitoring officer said in her evidence.
Yeah, it's just, you were saying that you should have raised it through appropriate protocols, and I'm actually saying that you have. So I was just asking that.
I'm not aware that you raised any concerns about this specific complaint with the Standards Committee before you make the video.
All right.
Thank you. And one final question to Simon from me. Regarding the video in question, which is really the heart of this breach, or alleged breach, much of the video talks around an issue. The bit that concerns yourself and the complaint is around the reading or the transcription of a pink paper report from Standards. Okay. From my viewing of that video, that statement basically delivers what the outcome of that complaint was. So my question here is, if Councillor Graves had just said this complaint wasn't upheld, is that the same as a breach which is being discussed today? Because from what I can see, from what he's read out, is basically the outcome. And is that in itself a breach of the code to publicly deliver the outcome of a standards complaint?
The normal process which most councils adopt, which is the one that you do, is that if a complaint does not result in a finding that a member has breached the code, then the details aren't published in terms of who the complaint was. They may publish, some councils publish summaries, which are broad, don't name the individuals. So that would be, the normal process would be you only publish details, you only give the name of the subject member and the details of what they've done, if there'd been a hearing and a finding to that effect. That's the normal process. And if anybody within that confidential process, whether they be a member of the standards committee or an officer, was to disclose information about complaints, then normally that would be actionable. If it was an officer through the new processes, if it was a member through these processes.
Okay. Any other questions? No? Okay, thank you. So we'll now move on to Councillor Graves's.
Chair, did you want to allow a 5-minute comfort break before we move on to Councillor Graves's part? Or
If everyone would like a comfort break for 5 minutes, yeah, we'll postpone.
If we all gather back at
okay to start, Steve?
Thank you, Alex, and welcome back, everybody. I will now invite Councillor Graves to present his case to the panel.
Thank you, Mr. Chairman. I'm actually going to go over a lot of things that have already been said, so you'll have to bear with me with that. Okay, so you made the call on the 22nd of May 2023 in the council chamber. I was being inaugurated as the new mayor of the city, the new first citizen for Derby. At the very moment the vote was confirmed, one of our newest councillors, Councillor X, decided to tweet that I was, and I quote, a racist, xenophobe, and a misogynist. Anyone that knows me, and we do have copies of that if anybody wants to see that. Anyone that knows me will know that that statement you made is untrue and libelous. What you may not know is that I sought the advice, as you do now, and protection of this council through our monitoring officer. I was advised that the council could do nothing without a formal complaint made through this committee, the Standards Committee. I spent, I looked it up, 6 months with attempts made to seek a resolution through the then leader of the Labour group, who unfortunately never responded to any of the correspondence. Eventually, a complaint was made, not directly through me, but by a member of the public and a senior member of Reform Derby. I have been questioned on many occasions as to why I did not bring this complaint personally, and I think that's been highlighted today. Quite simply, I did not want to bring the office of the mayor into question by bringing the complaint forward myself, as this would reflect badly on the mayoral office and the council. Despite a long process, the complaint was dismissed, or as I describe it, swept under the carpet. Councillor X apparently had to apologise to the council via the monitoring officer for potentially bringing the council into disrepute. Anyone with any sense of fair play can see the injustice of this so-called resolution. Unfortunately, the monitoring officer felt that this was appropriate and convinced an independent member that this was the best course of action for the council and resolved the case. For me, it did not resolve the case, as there was no justice for me. Not the first time, I might add. I felt let down by the process and let down by the monitoring officer whose help I had sought and advice I had followed. I decided my only recourse to highlight this was to make the video of the events that led to one of the many council injustices that I have experienced within the council. In my video, which you've now seen, made it clear that not only did Councillor X was guilty of this misdemeanour, but the monitoring officer was complicit in allowing the incident to go unchecked. I read out the report from the Standards Committee that was about me, although no one's name nor the exact details of the complaint was read out, as that is the nature of the reporting within the Standards Committee at that time. The report was less informative than it is now. You will be aware that whilst this report is within the pink papers, my rights under the Universal Declaration of Human Rights legislation, Article 19, and the International Covenant of the Civil and Political Rights allows me to speak about things that happened or happens to me. The pink papers in this instance refers to me. My proviso is that I have never before read any pink papers that report out in my 30 years of local government. I do take that very seriously. But then, those pink papers have never been about me. To reinforce my stance on this, other councils do not put these generic reports in the excluded part of the meeting, and we all know how the council uses best practice from other councils when it suits its agenda. Furthermore, since this case, the new report of standards and our response supports making these reports more open and more informative to the public, which has been progressed to a point. From the video, the monitoring officer decided to make the complaint herself, as allowed within the rules of the Standards Committee, against me. You can imagine the injustice becoming much worse. Councillor X makes an atrocious social media statement about me. I get reported to the Standards Committee, only in Derby City Council, where justice is being eroded little by little. I will add at this juncture that no complaint about the video has ever been received from any councillor or any member of the public, including all those, I've just heard it's 1,500, watch my video.
not even Councillor X. Now, while I accept that the complaint by the monitoring officer is within our rules, the details of those rules didn't foresee the bias and unfairness that could come from that rule. The video to which she refers mentions her specifically and criticises her decision making despite following her advice. Sometimes the rules we make do not account for the actions that might arise from them. Clearly, the monitoring officer felt she had the right and a good reason to initiate this complaint. As I say, the rules of this committee did not foresee such a situation arising. I believe the monitoring officer made two errors at the beginning of this complaint, reasons that I believe would negate this complaint. Firstly, the monitoring officer may have been biased in bringing this complaint, as she was heavily criticised in the video for her poor advice and lack of support for my case. Despite the rules not specifically accounting for such influence, her own legal code of conduct should have been prevented her from raising such a complaint. It could be seen as an abuse of power, as the monitoring officer is the only officer that can circumnavigate the committee standards process. Secondly, and equally damning, at the meeting where it was decided by this committee to initiate the continuance of the complaint was introduced by the complainer. In this instance, the monitoring officer. No other person is permitted to present their own complaint, and I would argue that neither is the monitoring officer. Had I been the chairman at the time, I would have disallowed it on that basis alone. The monitoring officer was therefore able to influence this committee into investigating a flawed case. Bearing in mind that there are 5 voting members of this committee, this was so flawed that the vote on that evening was 2 votes in favour, 1 against, and 2 abstentions. Put another way, 3 votes were not in favour. It was clear from that vote that members were very unsure about the advice they were being given. Furthermore, I was not permitted to raise this, as I was, myself, and quite rightly, excluded from that meeting, as it was about me. On that basis alone, I would ask you to ask yourself if a reasonable person would view those steps taken as reasonable. I will continue the saga. From that meeting, the complaint against me was investigated, and Councillor Prosser highlighted that the monitoring officer could be seen as having an undue interest in the investigation. At that point, the lead officer was changed to another solicitor of the council, a telling move, if I do say so myself. In fact, 2 solicitors, one from the council and an external solicitor, today. Personally, I was absolutely flabbergasted to be interviewed by an external solicitor who revealed that the cost of their services was around £5,000. £5,000 at a time when the council is struggling with finances, at a time when the council employs many leaders, and on a subject where the only recourse the council has within the Standards Committee is to request an apology or ask their group leader to remove them from a committee. £5,000 for what? To prove a point? So next, the Snoop solicitor interviews me and suggests I make an apology to the full council. I offered to do this in the form of a statement, similar to this address. At the very first request, I accepted. Unfortunately, after that acceptance, conditions were imposed, allegedly in line with previous precedent. I found this to be incredulous, and that I was asked to make a statement, come apology, but I had to show it to these officers before the agenda is set. It was found that some councillors had made apologies to apologies to various committees, such as the licensing committee, and other councillors had apologised directly to their complainants or the council via the monitoring officer. 3 attempts, full council meetings, were made to persuade me to show my apology statement prior to the full council agenda being set. As a compromise, I did offer to provide my statement an hour before the full council, similar to the answers to questions at full council. Unfortunately, that was declined. So you can see, members of this committee, how I got to this point. Right from the start, all I wanted was an apology from Councillor X for her rash statement, probably encouraged by her fellow councillor mates. However, I do not think she has the integrity or even admit her error of judgment. And for the monitoring officer to accept a mealy mouthed statement as a solution to this crass behaviour just did not wash with me. I've heard it say that officers need to be able to trust counsellors. And whilst I agree with that statement, it actually works both ways. I went to the monitoring officer in good faith, and I was let down twice. Once by facilitating an injustice against me, and then feeling she had to teach me a lesson for speaking out. Then this is followed up by initiating a complaint with undue influence against me. Issues I hope you consider carefully. I have seen many injustices throughout my time as a councillor. I have always tried to speak out about them. Many times seeking support from the incumbent mayor, and other times seeking support from senior officers of the council. I have come to accept that being let down is one of those consequences you have to deal with. No one's a winner here because no one listened and attributes a lot of public efforts with. A council that spends more time trying to sweep things under the carpet than trying to deal with the real public concerns. I think there's lots of things there for you to consider, as well as injustice and personal rights and procedure. Thank you, Mr. Chairman.
Thank you, Councillor Graves. Simon, if you have any questions for Councillor Graves.
I do a few. I'll try and be as quick as possible. So Councillor Graves, you've heard you've been a councillor for a long time. I think you told me you've been on and off the council for quite a number of years, that's right. And then you've been a member of the Standards Committee for quite a while. And you were a member of the Standards Committee at the time you posted the video.
Yes.
Correct. So you're familiar with the Standards Committee's procedures and processes? Yes.
Yeah.
And you were aware, and you told me in evidence that I think the phraseology you used is the details of the complainant or subject members don't get published unless they've been found guilty.
Yeah.
You said in the presentation you just gave that you felt that your only recourse to highlight the issue was to post this video. What other methods of recourse did you try and use before reaching that conclusion?
I've had informal discussions with Emily. I'm very disappointed to hear that she said that I didn't. I spoke to her when I was the mayor, saying that all I wanted was an apology. Unfortunately, the monitoring officer feel that conversation was had.
When did those conversations take place?
The date, I don't have a date. It was in the 6 months lead up to the complaint. Because if you see when I made a complaint, it actually happened in May, but the complaint went in November. So, you know, I mean, if it was rash, the complaint would have done straight away.
Now, I'm asking you about the recourse when you found out about the outcome of the complaint. So that was notified to the complainant in August, right. And you posted the video in November, and the Standards Committee was notified on the papers in September. So between August and November, and you posting the video, did you have any conversations with the monitoring officer about the outcome?
I have to be frank, and I don't know the dates that I had the conversation, but I have had conversations informally. Unfortunately, I'm not a legal person. I don't write everything down because I actually take people I trust.
I appreciate it's a long time ago and you might not have the exact dates, but you would know whether you had a conversation with her after you found out about the outcome of the complaint before you posted the video, surely?
Yes.
So you would, and did you?
Yes.
Specifically about the outcome of the complaint?
It might have been amongst a lot of other things, but as the mayor, I have had a lot of engagement with the monitoring officer because the mayor has that relationship.
And what did you ask her to do as a result of being
I'm not sure I asked her to specifically do anything. I think I expressed my concern that there was an injustice and that the requirement was for an apology. I think probably what I actually said was that whilst I think Councillor X said some things that I actually think could be taken to civil court, that wasn't the recourse I wanted to do because I didn't think it was necessary. I treated it as the fact that she was a new councillor, a newbie in there, and you know she did make a rash statement. And so I think the resolution, I expressed the resolution because all I wanted was an apology, and the matter would go away.
Can you express that directly to the monitoring officer after the complaint
I
had been finalised?
expressed it to many people.
Did you ever say to the monitoring officer that if the complaint, after you found out the outcome, was that when you got the committee pink papers, or did you know about it before then?
When I got the pink papers.
So,
Yeah. No. Actually, it was. I think Mr. Armstrong, Mr. XI, said that showed me the letter that came, which said that this was the final decision.
So that was in August, or
Probably, yeah. If you say so.
Well, that was when he was told about it. Did you ever suggest to the monitoring officer that unless a different outcome was achieved, you would publish something about the outcome of the complaint?
No, I didn't do that. No.
And did you suggest you wanted it referred back to the standards committee because you felt that it should consider what had happened in that case?
I don't believe that there is a process where you can refer it back. I stand corrected if there is, but I've never known anything referred back to the standards committee because, as the letter states, it's the final decision.
You didn't say, I think the process, the way this happened was wrong, standards committee.
No, Mr. Gocha. I have said the process has been wrong for many, many years, all the way through this. And I think Councillor Prosser was trying to raise another issue that had happened, which I personally felt was a terrible thing to be swept under the carpet, but it was. And I always raise those issues at the time and express a contrary view to the legal officers in this council because we do not deal with them in a way that I think the public would want us to deal with them. And so, yes, I have made lots of expressions of the fact that I think the system's wrong. And, as has been alluded to, some of those processes have changed. I think I might have had some influence in that.
So you accept that it's the standards committee that sets the policy and processes, not you?
Yes, absolutely, yes.
But you said in the recording that the standards committee doesn't fill you with any confidence.
Maybe those words were a little rash from myself, but no, they don't because of the constraints that they've got.
You were aware at the time that the standards committee process was to consider the outcome of complaints in exempt session and on, as the county calls it, pink papers.
Yes.
And did you seek any advice from anybody other than, or did you seek advice from anybody else before you decided to record the video?
No.
And when you said in the video, I'm a member of the standards committee, I'm supposed to keep these things hush hush, what did you mean by that?
That the rules of the committee say that you can't read words that don't mean anything out to anybody.
So you knew that the words, the decision was confidential and that you shouldn't be talking about it?
Yeah, but at the end of the day, you say that we shouldn't be revealing confidential information. I argue that there's no confidential information in the pink papers in the standards committee. In other committees, there are.
Because it didn't identify the details.
It didn't identify anything. Had I not known it was about me, I could have easily have gone past. And I had an occasion many years ago where there was something in the confidential papers about me, and I went into the committee, and one of the committee officers came and said I had to leave the meeting because it was about me. I didn't even know.
But you did know this was about you, didn't you? Because you've been advised not to attend the committee meeting.
Yes, which actually is something I question because I was advised not to come in because it was discussed. And yet, when you came into the committee meeting, there was no names mentioned. So how would I know it was about me? Only because an officer told me it was about me.
So you did know.
Well, actually, it was the monitoring officer.
So you did know it was about you.
Yes.
And the preamble of your video before you actually read out the wording says very detailed exactly what it was about, doesn't it?
Yes, but words in the pink papers. The rest of it is about me and what's happened to me. So I'm, you know, just because I put some words in front of it and after it, you know, doesn't mean that it changes the meanings of the words in the pink papers. The pink papers are deliberately opaque.
Why are they deliberately opaque?
Because I don't want people to know who's done what and what they've done.
Standards.
Yes.
And that's the policy of the Standards Committee of the Council.
I know where you're going with this, but carry on.
I've only got a couple more questions. You didn't make any comments on the draft report.
What did you want me to say? I mean, I thought it was your report.
And when it was suggested that you make an apology as an informal resolution by the Deputy Marshal, you agreed to do that?
I agreed to make a statement in the Marshal report.
Marshal Officer letter refers to an apology.
Yes, absolutely. So that's where I personally agreed to make a statement. And I agreed to use the word apology.
You did agree to use the word apology in a statement.
I did indeed, yes.
And you didn't, when the Marshal Officer first contacted you about the recording and asked you to take it down, you didn't do that?
No, I didn't. Not straight away.
How long did it take you to do it?
3 months.
Thank you. I don't have any more questions.
Arnold, questions, Arnold?
Could I just ask you, what did you think would happen after you posted the video?
Maybe I didn't think that far ahead. I thought maybe I'd raise the issue about the injustice that happens within this council, but I didn't expect what did happen. Maybe I would have expected a councillor to make a complaint. I'm not sure, but it didn't. That didn't enter my head. The reason I did it wasn't to think about what the consequences of it was. The reason for it was to raise the issue as being, in my view, wrong because there's an injustice. And then not just to me, there's been injustices many times over the years.
But were well, it seems to be from what you said that you were aware that what you were posting were matters that were of a private nature, there were things in the pink papers that you weren't meant to discuss.
I knew to raise eyebrows.
So you are saying you knew exactly what you were doing, really?
Well, Mr. Coach has already concluded that.
Well, okay. Yeah. So therefore, did you not think something would happen about this? I don't mean people supporting you. I mean people might have.
I didn't know what would happen. That wasn't. Sometimes you do things not because you think of what might happen. You do things because you believe in something. And that's what I believe in.
And would you have supported someone else doing a similar thing, let's say talking about you, if there's been a complaint made about?
I'm very relaxed.
You'd said something and they were talking about
The
it.
thing is, I am much more relaxed than many of our councillors. Many of our councillors have complaints because they've done something wrong or slightly wrong. They want it to be hidden. I think if I've done something wrong, then I should be held up to account for that. So I'm a bit more relaxed. I'm not the right person to ask that question. I mean, this is why I wanted this in open session.
Yeah.
I mean, I clearly knew this was going to happen. It's an open session, so you know, my neck's on the block.
But you would agree that you actually agreed yourself to the process of doing the established committee procedure. You voted them through yourself.
Mr. Coach has already concluded that.
Nothing else to add?
Any other questions? Councillor, just got you, when you opened your speech, you said that you didn't put the complaint initially because you didn't want to minimise us to some views.
Yes.
Had you not been a member, would you put the complaint in yourself?
Yes, absolutely. It's quite interesting because the monitoring officer at the very beginning of my tenure explained about the behaviour of the mayor, mainly in relation to the full council chamber, and that we had to uphold very high standards. And so that did influence how I could get a complaint in, because she told me that I needed to put a complaint in, and that was done through a party officer, Mr. Armstrong, who was our chairman of the party, and so that was a huge consideration. And the main reason for that, Councillor Rob, is that as the mayor of the city, chairing the full council meetings, how can the mayor sit there knowing that they made a complaint about one of the members that you're controlling? I just felt that integrity had to remain, and that's why I personally didn't put the complaint in.
Going back to saying you were prepared to make a statement apologising, why do you think your statement of apology wasn't accepted before full council?
Because you heard what I read, and I know that the officers of this council said you can't do it. I mean, and just for the record, you know that the council officers in this meeting tried to get this in a private session because they didn't want it to be held out in public.
From your perspective, you've got to do that and to put it to bed once and for all.
Absolutely. If I could have read that statement out, or a similar statement to that, in full council, it would have been done and dusted. The only thing I would have added to the end there is that I would have offered my apology.
Councillor Graves, thanks.
Yeah, Councillor Graves, you mentioned that, and you've already dealt with this in a way, Councillor, that you were saying that you thought it would badly reflect on the council if you, as mayor, were to make a complaint. You're kind of our chair in that meeting, yes, and you lead that meeting in many ways. Wouldn't it have been a good example of what people should do if they feel they're aggrieved, no matter what their position is, and that you can make that complaint and still work dispassionately and chair that meeting totally impartially?
Well, I hope that in my tenure as the mayor, that people feel that I did chair those meetings very neutrally and compassionately and properly. But your version of how you think should have gone is not the same as mine. I just feel that I should be making complaints about the councillors, any councillor, it doesn't matter what. I didn't think I should be doing that. I don't think the mayor should be doing that, because in some ways it starts to show impartiality. Partiality, and I didn't want to do that.
Secondly, eventually, part of relating to the process, you said that you were prepared to make an apology to the council. But you effectively embargoed any apology statement that you were making to an hour before council.
No, I didn't.
You said you would. Sorry, I misunderstood then. My understanding is that you said you were prepared to make an apology before council, and that you would present that the wording of that apology 1 hour before council began.
Okay. On many occasions, I was presented and said, as I said, I thought I read it out, but on the very first occasion, I was asked if I would make the statement in the full council. I immediately said yes. All right. I didn't say I wanted to hidden. I said yes. Then a subsequent email came and said, but if you do that, you've got to let me see what you're going to say. And I just think, as a councillor, I should be able to say what I want in the full council chamber within proper limits. And this was about this case. And so I said, well, no, I'm not prepared to give you my statement before the agenda is set. Because it has to be before the agenda is set. And that was asked of me, I can't remember, 2, maybe 3 times, I can't remember. And then I thought, well, how can I overcome this? So I gave
a compromise that I would give the statement an hour before the meeting, if that would help to resolve the situation. I was trying to resolve the situation, and that was rejected.
And did you present that form of words that you were going to use?
Well, no, because it was rejected.
Well, the idea was rejected.
Yes.
Right. If you had presented such a view, it is hypothetical, would it have been an unequivocal apology?
I can use that word just the same as you. Yes, no problem.
Right. And so therefore, at that stage, you had effectively admitted that you had breached the code of conduct and were going to apologise for it. Yeah. Thank you.
Councillor Prosser. Same question.
You're accused of being a racist, xenophobic misogynist.
Yeah.
Very serious accusation, Margaret, but how serious is usual? I mean, that is unusual.
I think what was unusual is that, I mean, obviously I've been called a lot of names by lots of people, but it was unusual for a new councillor to make those comments, not just about me, but about the mayor. In fact, she used a new mayor as the comment. So she was actually not just attacking me; she was attacking the office of the mayor. And so I found that quite disgusting, to be honest. And having said that, I appreciated the fact it might have been a rash thing for her to do. And I didn't want to pursue any legal case. I'm pretty sure I did speak to some legal people, and they told me I had a really good case of winning. But that's not what I'm about. I'm about trying to get things right within this local authority.
So you've had similar accusations, or you've had accusations in the past?
Yeah, not in the same way. Not in the same way. This was really right in your face. This is different. Yeah.
So it says that you first approached the Labour Party to deal with the complaint. Why did you do that?
Because I wanted a resolution. I didn't want to bring a complaint to this committee. Or I didn't want a complaint to come to this committee, because if you can have an informal resolution, surely that's the proper way to go about it. You try that first.
You said you were asked to not go to the standards committee that day because it was about you. And you've also said that in the past that's not happened. Why do you think that might have happened in this case? That's asking you to suppose something, but is there any difference between that day and the previous incident where there was a complaint against you?
Maybe I could have placed an argument and convince members that it was the wrong thing to do.
Well, I think probably one more. Because you were chair of the standards committee at this point, and I substituted you on that committee. And when the result of that particular complaint came out, I've already said I had quite an argument with Andy during that meeting. When I started to read out the result of that complaint, there had to be some conferring between officers to work out what the complaint actually was about and what complaint it was. Is that normal on the standards committee, that even the officers don't know what complaint they're talking about?
Occasionally, yes.
All right. So the report says that you weren't reasonable in releasing the information, or that it was in the public interest to release the information. Including you seem to think it's reasonable to release the information, and that the council is unreasonable in asking you not to do so. So why do you think it's right in this case to release this information?
I think the subject matter is reasonable. I don't think that the papers reveal anything whatsoever. If I'd have gone on the video and just read that out, I would have had 1,500 about the injustice. I know I'm here because of the specific thing about the words I've used, but I'm highlighting this as an injustice in this council that happens very, very frequently. And if somebody doesn't do it, it'll never get done. And I have to say, I'm very pleased with the progress this committee has made in doing those reporting, because we do have some very strange behaviour of councillors in all sorts of areas that goes, to say, unnoticed, because I use the phrase swept under the carpet, and many of them shouldn't be. They should at least be reported on, but nobody ever sees those.
Just a couple from me, Councillor Graves. Obviously, this panel's here today to judge whether you've breached or not, right or wrong. Do you feel that your statement and action was in the public interest?
Yes.
For what reason?
Well, I think the public can see some bad behaviour from time to time from political people, councillors, and what they don't see is the results of any of that, and that's because the swept under the carpet phrase comes about. So it is very much in the public interest, because from this meeting today, we have reporters in this room. They will report about this meeting, and therefore the public will then decide whether the council is right, whether I'm right. They'll have their own opinion. That's up to them. But it's very much in the public interest.
And you've said on a few occasions that, and I'm paraphrasing, to say that you feel that the system and the process has failed you in some way. Can you detail as a top three which bits of that process have failed you, and which has been the most significant?
Well, I'm hoping as councillors, when you first become a councillor, the very first time you become a councillor, you get induction meetings. And there's a lot in there, and a lot of it is presented by the legal department, Emily over there. And they talk about relationships between councillors and officers. They talk about protection, because the relationship between council officers is about protection of the officers. But it's also about protection of councillors. I actually believe that this council actually says it lends you some protection. I've not been protected. I have been slandered. Quite, not just me, but the mayoral office has been slandered, and I have not been protected by this council. And you will all know, most of you will know my history in this council. I have had some serious abuse over the years in that council chamber over there, okay? And not once did the monitoring officer at the time defend me, protect me, anything. Not once, all right? It allowed councillors to show that abuse and continue. And I admit they're trying to control the mayor, but where is the protection of councillors in that? And I think that's a serious thing, and you all need to be aware that you're not protected. And as I am not protected, I went to the monitoring officer looking for that protection, asking for protection, asking for her advice. And I followed her advice, and I'm still not protected.
Do you feel then, having gone through the process and sought advice, informally or formally, do you sit here today and genuinely feel that the course of action you've taken was the right one?
Yes, I do.
And finally, do you have any regrets of the action you took?
No, I don't have any regrets of the action I've taken. Because, and I'll make this very clear, you've seen Mr. Gocher, who we paid fortune to. We've had other officers involved. At every stage, all I had to do was make a public apology somewhere, and
they would have closed this whole thing down. But because I wasn't prepared to show them my statement, they weren't prepared for me to read that out in full council. We've got to this stage. And I do believe that the monitoring officer made some very early mistakes by presenting her own complaint. No other complainant is allowed to do that at all. And there's also the question of the fact that she is mentioned in the video, and you know, it was my sadness that she didn't help me enough in that process, and so there was a serious amount of criticism about her. And I don't think the rules of the standards committee reflect a situation like that. I think she's made some mistakes in bringing that here. She certainly made a mistake by presenting it herself, in my view, and that was proven by the fact that it got passed on to a different investigator. And so you could look at it from that angle, which we shouldn't have even got this far.
Are you aware that in the 10 or more years that I've been an independent person on the science committee, we've never discussed the case on the pink papers? Never. Not until council process.
What do you mean you've never discussed that?
We don't discuss the cases on the pink papers. The more we present them,
yeah,
and Stephen will present them and say, we've got this case, we're going through, one's been dismissed, blah, blah, blah. We never discuss the actual
we have
cases.
occasionally.
Never. Until the one that council process brought up, we've never done it.
Well, we have occasionally.
Well, I've been on the committee this over 10 years, we've never done it.
Hang on, whoa.
Sorry. But the problem is that when you're trying to discuss it, they say you're not allowed to say who it is.
That's
We're
right.
not allowed to tell you. We're not allowed to discuss what they did.
That's correct.
All right, and so most of the time it's not worth it. But when something is aggravates you, you do discuss it, and you haven't been to every meeting, Mr. Cameron. And there have been occasions where
I've possibly missed 2 meetings out of
yeah, I'm not saying that.
I'm just saying,
what I'm saying is
it's never happened.
Occasionally it has
Before
been
Emily
discussed.
was here, I'm just saying it's not something we discuss in the meeting. Stephen
But we should.
has
But we
been
should.
here longer than me. I'm sure he would confirm we don't discuss the pink paper, individual
But
cases at meetings.
I would question not bringing an officer into the
Sorry.
debate.
But maybe we should. Can I say that Alan wasn't at that meeting? He wasn't aware of how that discussion went or how deep that discussion was. So he can't really comment on how that compares with other standard meetings.
No, but he did.
And I can't either because I've not been to any of the others.
I know.
So
I'm just saying.
yeah.
Okay, I'm going to draw that to a close now. Thank you.
I think we should just clarify it's not something we discuss at
Point
we
taken.
we
Thank
don't do it.
I will now invite investigating officer Storm.
Thank you. I will kind of agree. First of all, I wanted to address the point that Councillor Graves made about the monitoring officer. The process provides for the monitoring officer to refer matters to the standards committee if she believes there's potentially been a breach of the code. She exercised that power, and then
Is this something else, Mr. Chairman?
yes, she exercised it because you suggested that when someone has an impact on the decision the standards committee is up to make, which it doesn't. I'm going to explain why.
But I would question we're here to debate Councillor Graves's conduct here.
Well, he raised it. If you're saying it's not relevant and you're not going to consider it, that's fine.
I would rather stick to the case that you presented.
Okay, so you're not going to consider what he said in relation to that point.
Everyone's heard it and they can draw their own conclusions.
I'd like to hear what you said.
Good. Please continue.
So the process has been followed in the standards committee procedure. I've been instructed by the deputy monitoring officer and have carried out the investigation. The only contact I've had with the monitoring officer is in her capacity as a witness in the process. That's the capacity in which she's attended before you today. It's your decision. You are the decision makers. I've carried out the investigation outside of the council and reached my conclusions, present them to you, but ultimately you're the decision makers. You are the custodians of the code of conduct within the council. It's your obligation to consider the council's duties and responsibilities under the Localism Act.
I'm being advised that we. Okay.
So you are the custodians of the code, effectively. Your decision today reflects the council's view on how members are bound by the code of conduct. We've heard quite a lot about the previous complaint, which was the subject of the video. I'm not going to go into that because ultimately that's not what the case is about. What I will say is, and I did reflect in the report, I do understand, given the comments that were made about Councillor Graves, why he was unhappy about them, and why he feels the way he does about those comments. And you know, that's totally understandable. I would, if someone said that about me, I would be angry. But the point of this particular referral and what you have to consider is the steps that he took in relation to that. He knew, he actually said on the video that it was hush hush and he shouldn't be talking about it. He knew what the standards committee processes were. He knew the way in which complaints were being dealt with and considered. And he took the conscious decision, because it was a decision he did not agree with and didn't like, that he could take the law into his own hands and publish information which he knew the council would not publish, because that was the standards committee process. He decided to depart from that. The only justification he is given is that he believes it in the public interest. Whether he believes it in the public interest is not the test. The test is whether it actually is in the public interest, and also that he complied in doing so with any reasonable requirements of the authority. He never sought the authority's views or approval in doing it. He took it off his own back to do it because he was unhappy about the process. And if you conclude that a councillor can do that and disclose confidential information that they know to be confidential because they don't like the decision, then that is a very dangerous precedent for you as a standards committee to set, in my view, and that is the reason why the Montreal this happened earlier. Members are bound by the code, they sign up to be bound by the code, and there should be consequences if they fail to comply with the code. Councillor Graves said in response to the Deputy Monitoring Officer and today that he offered to make the statement to council and apologise because he accepted that he breached the code. So in my submission, that's the only decision that you could possibly make today on the evidence before you, that he did breach the code in acting as he did.
Thank you, Sam. Councillor Graves.
What to say, because I've said everything I've said. It's whilst I understand where this approach is coming from. Sometimes things are much more in depth than just whether it's right or wrong. There is a real case here of injustice. I believe that I've been dealt an injustice, and I felt that the only recourse I had was to go down the route I had, so that I could get to either this situation or to the full council or whatever, where, I mean, had the complaint not gone, the video would have been there, still online, probably 1,501 people would have seen it by now, and that would have been my justice. It's not what I wanted, but it was the only way that I've been trained by the council that you can do it, that they rely on the public facing things, they rely on the press to highlight their issues. You know, I accept the fact that I read applicant papers, so I don't believe that they are confidential. And so therefore I believe there are mitigating circumstances in this situation. And I'm going to leave it up to committee members to decide what the fate is. Thank you.
Thank you, Councillor Graves. It's now time for this panel to make our deliberations, which will be done in private, so we'll adjourn while we do that. Thank you.
we're live again.
Thank you, and welcome back, everybody, and thank you for your patience while we undertook our deliberations. The panel has come to a conclusion, and we've considered the representations made by the investigating officer and the subject member, as well as the written evidence forming the hearing pack. We're satisfied that Councillor Graves genuinely believed that in the way he conducted himself, he felt justified that he was reasonable and in the public interest to do so. We are also satisfied that he made the decision in good faith. However, we are not satisfied that prior to doing so, he sought the reasonable requirements of the authority as to justify the publication. In those circumstances, our decision is that by his conduct and by his own admission, that Councillor Graves breached the Code of Conduct. We will now take representations from the parties about appropriate sanctions. I would caveat that just by saying that we did have quite a lengthy in-depth discussion and everyone made their opinions clear and open. And I will state as a matter of record that I am not minded to see any sanctions placed on Councillor Graves because of this.
I can also just add that the chair took advice on that. In making that statement, it's a predisposition at this stage. It has not predetermined his opposition. Hence, he's now inviting representations as to sanctions.
Thank you. That's helpful. I mean, obviously, you'll be aware the range of sanctions available to you is relatively limited in any event, and it's set out at paragraph 4.14 of the Deputy Monitoring Officer's report. I hear what you say and what you said about the findings. Obviously, there is a breach, and you've heard from the monitoring officer and me about the potential implications of that in terms of disclosure of confidential information. So I don't express any strong views about what sanction you should impose. I think that's more appropriate for you and your role rather than me as an investigating officer looking at this case in isolation. But the ones that would seem to me to be potentially relevant are, A, censure and apology. The member has actually indicated to you that it's willing to apologise and would apologise. Potentially reporting the findings to council. It seems unlikely that you would be minded to exercise the discretion that you have to recommend to the group leader that the member be removed from any or all committees. I would say that in other circumstances, I might say, given his role on the Standards Committee and the nature of the complaint, that might be something you would consider. And also you might consider some training potentially as well. So I put it no stronger than those are the ones that seem to me potentially relevant to your considerations, but obviously it is a matter for you what, if any, sanctions you think are appropriate in the case.
Alan, I'll go over to you. We'll now thank you for everyone's input. Unfortunately, I'm now going to have to adjourn the meeting again to deliberate what sanctions and actions should be taken subject to this meeting.
live again.
Thank you, everyone, and welcome back. I can confirm that the panel has now made decisions on sanctions and recommendations. Firstly, the decision is to apply no sanctions to Councillor Graves. Reason being, we recognise that Alan believed he was acting in the public interest. He was entitled to feel aggrieved by the original social media post and comments and the outcome of the standards procedure. And there was also an admission that the code of conduct had been breached, considered a significant mitigating factor. Our recommendations, agreement that the Standards Committee review changes made in 24 to assess the efficacy by November 25, noting the following: adoption by the Council of new procedure for establishing informal and local resolutions, greater transparency of complaints reporting to Standards Committee, summary table to be available on the website at all times, recourse to complaint for comments on informal resolutions before complaints are dismissed. Further, we recommend social media training for all councillors to be incorporated in the annual training programme, review of complaints form to ensure the correct information is being captured, emphasis on mediation between group leaders and whips on matters of contention between political groups before recourse to the formal procedure. And finally, clear guidance on how councillors can seek redress when they have exhausted the council's established standards procedures and are not satisfied with the outcome. So that concludes our meeting for this evening. I can thank everyone for their extensive amount of time today. I think we can all agree we'd like to see a resolution in this matter. Thank you.
Just to confirm, decision notice will be published within 7 days.
Yes, just to confirm, a decision notice from the outcome of this meeting will be published within 7 days. Thank you.